Okay, we ready? Ms. Newell, you were all over our docket today, but do you want to reserve 5 minutes in this case?
Yes, thank you, Judge Morris.
Okay.
May it please the court, my name is Erin Newell with the Florida Appeals for the appellant Major Paris. This court should reverse the trial court's orders dismissing MP's impleader complaint with prejudice as a matter of law, vacating the notices to appear, and order granting motion to initiate statutory proceedings supplementary, and granting the impleader defendants motions to stay the proceedings supplementary in order to make a threshold determination of whether the impleader claims could, quote, legally proceed against the impleader defendants. This court's standard of review is de novo on these questions of law. There's no dispute that MP is a creditor under the proceedings supplementary statute, and MP did initiate these proceedings supplementary to execution pursuant to that statute, which is section 56.29. MP obtained the judgment against the debtor Williams after being assigned claims for quantum merit fees by Williams' prior attorneys, Dolce and Clune, and their respective law firms. The quantum merit action was commenced by those prior attorneys, and they alleged that they had provided the legal services over the course of 2 years in litigation of Ms. Williams' suit for personal injuries arising from sexual misconduct against a professional baseball player. When that case settled, a few months after Ms. Williams obtained new counsel, there arose a dispute as to the payment of fees which were not made to those attorneys. So the quantum merit suit was commenced. That suit also included Jonathan Heller and the law offices of Jonathan Heller, who are the successor attorneys in that case. And the claims there were for declaratory relief to determine the rights of the property, which was the settlement monies, and which was in question at that point in time in 2013. During the course of that, Major Paris was assigned those claims and was named as a party plaintiff. And the claims against Heller and the law firm of Heller were voluntarily dismissed pursuant to a general release, which Clune, Dolce, and Major Paris executed in favor of Heller. That general release did not identify the personal injury lawsuit. It did not identify—
If I could focus you a little bit on this case. First of all, this is an outrageous set of facts, to be honest with you. It stuns you to read it, I mean, quite frankly. But the bigger issue in this case is whether or not these choses in action relate to the nature of the attorney-client relationship. And if they do, they're not assignable and you have nothing to chase. Isn't that really kind of the key issue in this case?
Yes, I believe it is, Your Honor.
Okay. I mean, it appears clearly that this was about the failure to receive the settlement funds and pay all attorneys, even those that were prior attorneys. That did not happen, even though it appeared to have been promised to happen. It didn't happen. So, yeah, I mean, that's what it appears. So this clearly relates to an attorney-client relationship. It's at least malpractice. It might even be theft. You know, I'm not sure, you know, but it clearly relates to the relationship, and the case law is very clear that such actions are not assignable. So, I mean, this doesn't seem to be a very complicated case from that standpoint. So why don't you address that point?
And Your Honor, I would disagree that the case law is clear that such actions are not assignable in the context of a 56.29 proceeding supplementary to execution. And the case that I would directly point you to is out of the 4th District Court of Appeal, and that case is Kraft. That was in 2000. What Kraft does is it discusses the identification of property under the statute. That's contained in subsection 6 of 56.29. And subsection 6 states, the court may order any property, debt, or other obligation due to the judgment debtor in the hands or under control of any person subject to the notice to appear to be levied upon and applied towards satisfaction of the judgment debt. Now, here the question is, does the interests that the chosen action go to, are those interests by the debtor in the nature of property interest, or are they personal?
And this is where I think your analysis goes off, because you jump to the end of what comes about from a chosen action, which is getting money, versus the chosen action. Your alleged property interest here is a chosen action. That is what it is.
Correct.
And it's unliquidated. It is technically unliquidated at this point because it is just a possible chosen action. And that is necessarily so because of the impleader context that you are in, right?
Yes, I accept that the context is unclear. And
No. To me, it's very clear. I mean, you are trying to stand in the shoes of a judgment debtor in order to raise a potential claim that judgment debtor would have against their former attorney. That's a chosen action, and it can be a property interest, but it's a property interest that has to be determined. Whether or not it is a property interest has to be determined by whether or not it's a viable chosen action, which goes to Judge Morris's point, which is that it probably isn't because you can't assign these kinds of claims.
well, Your Honor, I think to answer that question, you have to look at what's actually in the record, right? So what is alleged in the notice to appear? If you look at the notice to appear on page 814 of the record, it specifically states that the impleader defendant is in possession of attorney's fees paid to impleader defendant from settlement proceeds in the personal injury case that should be used to satisfy a final judgment in favor of Major Paris. That was supported by that email that's attached to the motion that states that promise to pay prior attorney's fees. So if we're going to discuss, and additionally, we even have an impleader complaint, which states various causes of action. So if we're going to discuss this from the standpoint of whether this would be an assignable legal malpractice case, we have to look at the nature of the legal services themselves. What's actually at issue here? And that's Cohen versus Kaplan. Specifically holds that we need to look at the legal services. So what legal services are at issue in this potential chosen action? And that is a promise in the nature of an indemnification. This is a promise that is not required under law by an attorney to make when he comes into a case as a successor attorney. It's unusual that a successor attorney would say to a potential client, well, you know what? I'm actually going to help you out. And if we get a settlement, I'm going to pay all of your prior counsel's liens from the settlement rests. So this isn't a standard attorney-client relationship. It in fact involves third parties to whom the successor attorneys have no obligation.
Ms. Newell, I mean, basically, her lawyer basically said, don't worry, we're going to take care of you. We're going to receive this money, pay ourselves, and we're going to pay everybody else. If that's not an attorney-client relationship, I don't know what one is. They received the settlement for her benefit and promised her how they would disperse it, and they didn't.
Yes, Your Honor, but to promise to pay her obligation, it is generally when a client obtains new counsel.
Lawyers do that all the time. They receive clients' money all the time and pay it out and settle claims against the client. That's a very normal lawyer function.
That may be true, but it's not a legal obligation of the successor lawyer to do so. And quite frankly,
it is if they tell her they're going to do so, then she authorizes them to receive the money on that basis.
And
she changed position and reliance on what they told her.
And that's where the chose would exactly be decided on those elements. However, we need to get back to whether this is in the nature of an injury to property or whether it can be classified as a personal injury. And really the only case law that's on point comes out of the 4th District Court of Appeal. There are 2 cases interpreting subsection 6 out of the 4th. And really it starts with Puzo, which was an earlier case out of the 4th. But Puzo specifically states that the court must interpret the word property in this statute as a broad term. These statutes are intended to enable a creditor to reach out and seize any assets that would be able to be used to satisfy a valid debt. So when we look at the word property, the question is this in the nature of an injury to property? And in Kraft, the causes of action that were alleged by the creditor revolved around allegations that the former husband, who was the debtor, his sons, and his son's law firm were not handling his financial interests that the law firm was managing for that former husband properly. So the management of assets by a law firm who's engaged to do that, I would suggest, is just as much in the nature of an attorney-client relationship. What's at issue is the actual cause of action that was stated, and that went to a property interest. And that's what the court found. More importantly, in Kraft, the court distinguishes and explains its prior decision in Mickler, which is a 1986 case. So that had been 14 years previous. And in Mickler, it specifically noted that the creditor in Mickler, who had been a plaintiff, who had sustained auto injuries and succeeded against the driver, who was the defendant, those claims that she tried to implead against the defendant debtor's attorneys specifically sounded in the legal duty. They were that the defendant's attorneys had committed malpractice in defending the case. So when you look at what a legal malpractice plaintiff must actually prove, if you look at the black letter law, it involves an attorney's negligence, neglect of a reasonable duty. And that's not what's being alleged in this impleader complaint. It's not what's being alleged in the notice to appear, and it's not what's being alleged in the motion to initiate proceedings supplementary. What's being alleged is that, hey, these subsequent attorneys said to this client, we're going to take care of you. Don't you worry about your obligations that you have to these other third parties. We're going to cover you when this happens. So come on and let us represent you. So while certainly it cannot be argued that this was not in the nature of an attorney-client relationship or attention, it does most certainly involve property interest and injury to property. And because subsection 6 of this statute is construed broadly to encompass these choses in action, it does cover this particular claim. A chosen action is defined as a right to receive or recover a debt, demand, or damages on a cause of action ex contractu or for a tort or omission of a duty. That's in PUSO. PUSO decides that prospective chosen action are reachable. That is the law. That is how it is interpreted of this statute. And there's been no dispute or any authority out of the other districts that have challenged that. So because of those reasons, this is a reachable property right that the creditor should be able to pursue against these third parties. Going back to some of the statutory requirements at issue here is the notice to appear. And this is really a pivotal document in this case, as per the statute. This is subsection 2. When the notice to appear is issued, it contains very important deadlines, and the rights of those impleader defendants are defined in this document per the statute. One of those requirements is that within 7 business days from the date of service of the notice to appear, there must be an affidavit stating why the attorney's fees paid to the impleader defendant from the settlement proceeds should not be applied to satisfy the judgment. That was not done here. If these arguments were that, you know what, we actually didn't have to pay you guys. We didn't have to pay those prior attorneys because any number of reasons. There weren't any valid charging means. We thought it was unfair that you ended up getting the judgment. Any of those equitable grounds that have been subsequently raised months after this notice to appear, nearly a year after this notice to appear was issued, were not raised. The impleader defendants simply took a chance on whether they had to follow this notice to appear, and they chose not to do it, apparently. And because of that, the court's subsequent orders are wrong as a matter of law. The court does not.
But help me out with that, because it seems like that the issues they raised, maybe they didn't raise it in the formal way that you mentioned, but you're not telling me that by virtue of them not raising that in a formal affidavit, that your clients were deprived of the ability to defend against that or to raise arguments about it, are you? You made arguments to the trial court about this, right?
Your Honor, our client was deprived of the right to pursue these proceedings supplementary per the statute.
Can I keep you on my question? My question is, were you deprived of the ability to raise these issues about, hey, this is not like the assignable debt or the non-assignable claims that Fourth District has held you can't use. This is properly more like an indemnification claim. Were you able to raise those arguments to the trial court?
Your Honor, we were not able to raise them in a meaningful way because attempts to obtain discovery were objected to. And in fact, the appellant, the plaintiff below, the impleader plaintiff, filed a motion for sanctions in order to show cause on February 10th, prior to the affidavits being submitted, stating these exact issues. That's on the record at 868.
Yeah.
So these issues are dispositive under the statute. They did prevent this mechanism, which is meant by the legislature to be an efficient summary procedure.
I just find that hard to accept that you all were deprived of the ability to present that argument when it seems like the trial court's, the order that we're dealing with before us has a pretty thorough rendition of what the arguments were and where it landed.
Your Honor, that order is a result of a motion for rehearing on an interlocutory order.
Yeah.
There was no evidence presented. It was based on the argument of counsel that was unsworn. So absolutely, Your Honor, if you're
So you believe that evidence would help fill in the gaps on the
Absolutely.
legal issues about what kind of claim this is, what kind of chosen action this is, because that's really the
Yeah.
essential issue.
Ms. Newell, you're just about to your 15-minute mark, so
Thank you, Judge Moore.
yeah, use your time any way you want.
Thank you. To answer Judge Lucas's question, absolutely. There's no evidence in this record as to what the nature of that promise was. The impleader defendants did not respond to discovery to define this relationship. The impleader defendants simply said, we were not obligated to pay unfiled charging liens, and so we didn't pay them. But there is absolutely no evidence as to the scope of their obligation to Ms. Williams, and that evidence would be helpful in defining the extent of this relationship and the causes of action.
Got it.
Because the fundamental question in this case is whether a judgment creditor can execute upon a chose of action held by its judgment debtor against third parties under this statute. The answer has to be yes, under the statute. As such, the court should reverse the trial court's orders dismissing the impleader complaint as a matter of law, vacating the notices to appear, and imposing this additional threshold step beyond what the statute requires. Thank you.
Okay, you'll have 4 minutes left when you come back, okay?
Thank you.
Okay, Mr. Cole, Mr. Waldman, how are you going to divide your 20?
Judge Morris, hi. Good morning. May it please the court. May it please Ms. Newell and Mr. Waldman. We're going to split it evenly with the
Okay.
court permission. I'll go first on
Okay.
behalf of the All Red defendants. And good morning. My name is Scott Cole. I'm here on behalf of the All Red defendants. I would just like to say that Judge Schenko's orders granting them, vacating the order, granting the motion to initiate supplementary proceedings, quashing the notice to appear, and dismissing the impleader complaint should be affirmed. And they should be affirmed for 3 reasons. First and foremost, as Judge Morris and Judge Lucas, you pointed out, these are legal malpractice claims that are simply not assignable. In fact, I believe I heard Ms. Newell say that what occurred here arose out of the attorney-client relationship, which in fact it did. Their whole case and the reason they believe they have a right to seek these fees from Heller and Allred is the email that was sent by Mr. Heller to their client, Ms. Williams, our client, Ms. Williams. And that's what they hold their whole case is based on. In fact, they say that in their summary of the argument, that that's the fundamental issue. Do they have a right to attach and try and go after Heller and Allred for their failure to pay their prior attorney's fees lien? And that clearly, as you pointed out, Judge Morris, and you pointed out, Judge Lucas, arises out of the attorney-client relationship. In fact, during one of the hearings before the trial judge, they admitted, M&P, and I call him M&P, Major Paris, they admitted that the only relationship between Heller and Allred and Ms. Williams was attorney-client. There was no other relationship. They also admitted in their pleadings that they stood in the shoes of Ms. Williams. The order that allowed them to file the impleader complaint and proceed with the proceeding supplementary sounded in legal malpractice, as did their impleader complaint. So it is clear that the only relationship here, and they have admitted it, and everything here that they're seeking arises out of the attorney-client relationship, arises solely out of the attorney-client relationship. It's not assignable, and they cannot proceed with their claim.
Could you address the distinction between this scenario and Cowan, Leibowitz, and Latman, and that arise out of attorney-client relationship?
Judge Atkinson, I apologize. I couldn't hear the last part of your question. You asked me to...
The attorney-client relationship at issue in Cowan, Leibowitz, and Latman. Can you draw a distinction?
Yes, Your Honor. You know,
Kaplan.
Right. I believe that they were talking about the Kraft case as well. And we rely on the Mickler case, which is a 4th DCA case, which the Mickler case clearly says in proceeding supplementary that legal malpractice claims are non-assignable. They relied on other cases which claim that they are, but those cases were not the same facts here. In fact, I point to the Kraft case, and the Kraft case states, and I'm going to read from the case, this is also a 4th DCA case, where the causes of action all revolve around the former husband's allegations that his 2 sons, the son's law firm, the former wife, a daughter-in-law, and others fraudulently mishandled various business and financial interests, which the law firm was managing for the former husband. That is not a relationship that solely arises out of the attorney-client relationship, because you have a husband with his wife, claiming his wife mishandled his affairs, claiming his sons mishandled his affairs, claiming his daughter-in-law mishandled his affairs. So that's not solely the attorney-client relationship that we have here, one that is personal to the client, Ms. Williams, and one that is built on trust. That situation involves several other factors. That is why the 4th DCA allowed in that case and the other cases cited by the appellants to proceed in proceeding supplementary. But in the Mickler case, which restates the law of Florida, which is undisputed, if it arises out of the attorney-client relationship, it is not assignable and Major Paris cannot bring the action. There's simply no exception on these facts for that. With regard to, I'm sorry, I didn't know if you had another.
Go ahead.
Judge Axe, I apologize. With regard to a couple of other reasons why we believe Judge Schenko should
I was just going to thank you for rescuing me from, referring to the wrong case. You know what I meant.
Well, you scared me for a second. I thought, am I reading the wrong case? So
No, thank you.
hopefully we're on the same wavelength now. Another reason why, and that they simply cannot proceed with this action, is because they had no valid charging lien. They admitted in a prior case before this court that they didn't file a charging lien. They voluntarily withdrew before a contingency occurred. They never claimed that they were discharged. And later on, they did a self-serving affidavit claiming, well, they had to withdraw for ethical reasons. But on this record, that's clearly not supported. It's not supported by their own emails telling Ms. Williams why they had to withdraw. It's not supported by their motion to withdraw. It's not supported by the order to withdraw. And it's not supported by their own actions that after they withdrew, they were still willing to help Ms. Williams try and negotiate a settlement. So not only is this a non-assignable legal malpractice case, but they never had a valid charging lien, so they have no right to be paid by Heller and Allred for their charging lien. And it's important to note that there was and as you pointed out, Judge Morris, the facts here are pretty outrageous, that Ms. Williams went through several lawyers. The first lawyer, Mr. Itzler, filed a valid charging lien, and he was paid out of those proceeds. These lawyers didn't. They had no right to be paid because they voluntarily withdrew before contingency occurred. Therefore, they weren't paid. And the third reason, and I think I want to point out that why Judge Schenko and Judge Lucas, you raised the procedure that Judge Schenko, the trial judge, did, and reaching the conclusion he did in this case, basically vacating the order, allowing the impleader complaint to be filed. And I want to point that out. First and foremost, they had not only one opportunity to be heard, but 2 opportunities to be heard. My clients did file affidavits. The trial court had a hearing on these issues. The trial court had a second hearing on these issues and then reached his conclusions. The trial court said, look, we don't need full discovery. We don't need motion for summary judgment. I don't need to see affirmative defenses. I can look at this cold record and say that both these parties were dismissed by the general release, and I'm sure Mr. Waldman will address that in great detail, that this all arose out of the attorney-client relationship, and they didn't have a charging lien. This is the third time these parties have been in before the trial court, and it's their second appeal. The judge was right, based upon this record, to end these proceedings and say, there's no valid basis here to go forward. We don't need to get all these, go through discovery and unnecessary discovery, waste the court's time, waste the taxpayers' money. They had a full and fair opportunity to be heard. And most importantly, I wanted to point out, and you again raised it, Judge Morris, about the outrageousness of these facts. When they went to apply for the proceeding supplementary, they never told the trial judge there was a release. They never told the trial judge they obtained $300,000 from Ms. Williams, which they claim was a sanction, not an attorney's fee. They never told the trial judge how the final judgment came about. Their client didn't appear for any proceedings. And most importantly, they didn't put Heller or Allred on notice that they were pursuing these actions. And I think that when you go ex parte before the court, and they're allowed to have this ex parte, you have to come with a little bit of good faith, and they didn't. And that just shows another reason why the trial judge should be affirmed. And I'm not saying Ms. Newell had anything to do with it. She didn't. She's appellate counsel only. But if you look at the whole picture here, the trial judge should be affirmed for a variety of reasons. Non-assignability, they didn't have a valid lien, the release, and I will say the unclean hands they came before the court with. And for those reasons, I'll cede the rest of my time to Mr. Waldman. We ask that the court affirm.
Okay, thank you. Mr. Waldman?
Good morning. May it please the court, my name is Glenn Waldman. I'm in Fort Lauderdale. I represent the impled defendants, appellees, Mr. Heller, who's a lawyer, and he's with us today observing these proceedings, and his law firm, the law offices of Jonathan Heller. Judge Morris, I did want to start out also because obviously I listened at the very beginning, at the outset, when you said this is an outrageous set of facts. It is. It's outrageous because of the release itself and the voluntary dismissal.
Well, it's outrageous because this woman was really victimized by a bunch of lawyers.
Well, not by Mr. Heller, though. With all due respect, not by Mr. Heller. And that's what I wanted to tell you, because at the 15-minute mark, Ms. Newell said that, well, and I wrote it down, there's no evidence in the record as to what was promised. And then you even remarked, Judge Morris, well, maybe there was a theft there. There wasn't. And for your note taking, and I know this is being recorded, but if you look at page, and I believe it's 907 of the record, that is where you'll find what was promised by and between Mr. Heller and his client. This was, there's an email thread. It's October 23, 2012, where Mr. Heller says, I'm reducing my fees to you. He did the right thing. He's an honorable lawyer. He's been practicing 40 years here continuously in the state of Florida. And he said, we have reduced our contractual fee of 40% to 31.8%, or $550,000. From our fees, we will pay, this is the promise that Ms. Newell says is not on the record, but it is. We will pay all prior attorneys' charging liens for fees and costs. And as Mr. Cole accurately reported to you, what happened was there was one duly perfected charging lien of Peter Itzler, a prior attorney for Ms. Williams, and that was paid in full. So let me come back to that. So the impleader plaintiff appellant law firm has as its founding partner, Scott Major. He became a lawyer in 1988, and at the time of the negotiation, execution, and delivery of the operative June 29, 2017 release, Mr. Major, for his part, had been practicing almost 30 years. If you look at his website, he specifically mentions his proficiency in state and federal appeals, among many other practice areas. And I mention these points because this was a highly sophisticated commercial lawyer signing the broadest form of general release, which these lawyer parties, Mr. Heller included, could conceive for this occasion. And this occasion was to completely and forever resolve the November 19, 2013 complaint for attorney's fees. And when you look back at page 6, paragraph 24 of that complaint, the underpinning of this supplementary proceeding was the earlier lawsuit starting with the November 19, 2013 complaint. Please take a look at page 6, paragraph 24, where they even alleged that there were no notices of charging lien ever filed with the court. And the absence of that perfected charging lien, as Mr. Cole reported, was validated by this court in Williams versus Victim Justice PC, which is found at 198 Southern 3rd, 822, and you'll find it there in black and white at footnote 3. So notwithstanding all of that, the appellant law firm here sought again in its January 2, 2020 impleader complaint, the very same entirely duplicative attorney's fees, which had been released. And when Mr. Major signed the release individually and for his law firm, he knew that Florida law provided, whereas here, and I'm quoting, the language of a release is clear and unambiguous. A court cannot entertain evidence contrary to its plain meaning. And in our briefs, we cite the Cerniglia case, Cerniglia, which is found at 679 Southern 2nd, 1160, a Florida Supreme Court case from 1996. And also important, in the proceedings below, never did the Major Paris law firm ever preserve for review here that the general release was itself ambiguous. Another maxim applicable to this case, and as previously stated by this court on multiple occasions, and I'm quoting, generally, Florida courts enforce general releases to further the policy of encouraging settlements. And for that quote, I cite to you Abbas, A-B-I-S versus Tudin, T-U-D-I-N. It's found at 18 Southern 3rd, 666, an opinion of this court from 2009. Also stated in Carey, C-A-R-E-Y, versus All Transport, Inc., at 989 Southern 2nd, 1201 from 2008. And I just note, because that's a point of interest, that Justice Kennedy, who was on the court at the time, served on both panels in those two decisions. Now, the appellant here was facing a hearing on the Heller defendant's motion for summary judgment and two proposals for settlement, and offered the release and it was designed, that offering of the lease was designed to encourage a fulsome settlement. So in the very little time I have left, I just want to focus on the actual language of the release, because it's just vitally important. And while we believe it's dispositive and you need not reach any other issues, and I know it sounds like, Judge Morris, for your part, perhaps you want to reach the issue, and you too, Judge Lucas, the issue of assignability and whether appellant can stand in the shoes of Heller's former client, Ms. Williams, or whether appellant should be a stop because Mr. Heller clearly and materially changed his position in reliance not only on the release, but the voluntary dismissal, which followed on July 13, 2017. And he gave up his own right to seek remuneration of his own attorney's fees when he settled. So let me go to the release, because as Judge Schenko pointed out, this release was customized here to bring this to conclusion forever. So if you have the release before you, or I know it's in multiple places in the record, but let me just point out a couple things. The release was offered by not just the plaintiffs, but by Scott Major individually, his law firm Major Paribus, and was executed and delivered to the Heller defendants. And it said, and I'm quoting, it was to forever, emphasizing forever, discharge the second party, which are the Heller parties, from any and all manner of actions, causes of action, suits, sums of money, etc. And I know you've seen that type of templated language before. Claims and demands whatsoever in law or in equity. Obviously, and you've seen these types of releases, this is the broadest language designed to capture any claim. It goes on, though, to say which said parties ever had, now have, or which any legal representative, and here's where I wish to focus, predecessor, successor, heir, or sign of said parties hereafter can, shall, or may have against the Heller entities. This language dealing with predecessors and successors is a point of emphasis, because it contemplated future claims such as this claim, which was brought 2 years later, and more importantly, certainly covers paragraph 14 of the impleader complaint, where the appellant law firm here claims standing as the successor to its predecessor, Ms. Williams. So it's absolutely dealt with. There is no serious factual dispute about that. The release goes on to say, in that certain action style, victim justice, etc., which is case 13 CA 003181. The release was given in this case, for this case, the same case number. There was no limiting language, Your Honors, in this release, which accepted this supplementary claim or any other claim. The release goes on to say it covers any and all claims of Major Paris, or which hereafter will arise out of the, quote, subject matter of the lawsuit. This was a modifier insisted upon by the Heller parties to avoid all doubt, to avoid all parole, to avoid all discovery, to avoid this appeal, because the subject matter of the lawsuit was the same as the fees in the supplementary complaint. They are the same. The release goes on to say it shall, quote, further cover charging liens filed, or as here, and I'm quoting, unfiled charging liens, attorney's fees, costs, etc., etc. Again, this was customized in order to avoid all doubt in respect of the origin of the claim having to do with Heller's agreement with Williams, Ms. Williams, upon settlement. And finally, you'll see in the release something unusual, where Heller insisted and Major gave, quote, Scott Major and Major Paris warrant and represent that they have full authority to execute this instrument, releasing any and all such claims. So I'll just finish by jumping all the way forward to the second hearing. This gets back to Judge Lucas, what you were asking. Well, did you have an opportunity, Ms. Newell, did your clients have an opportunity to litigate these matters? Well, they had multiple lengthy hearings, and those transcripts are part of the record. But at the last hearing, which was June 23, 2020, last year, Judge Shenko allowed Major Porowitz's motion for reconsideration and clarification on all of these issues, in which the appellant law firm sought an opportunity to conduct discovery on the intent of the unambiguous release. And here's what happens there. If you go to page 11 of that 56-page transcript, Mr. Winston, a lawyer who was representing the major law firm, said this at line 11. We're not saying that the it was modifying or referring to this release. He said, quote, we're not saying it may not be a valid defense. It may at least to the Heller defendants. And so then Judge Shenko interrupted him and said at line 20, what do you need for the release? I mean, you folks negotiated it. And then he went on, Judge Shenko did, at page 12, line 5, page 24, line 16, to describe Major's Gordian-knotted efforts to avoid the release, calling it circular. He called it circular twice. But I submit Judge Shenko was being charitable. The arguments that appellant fashions in support of the claim are not just circular, they're sanctionable. And Judge Morris, they are outrageous. Just as you said, they are outrageous. This is why the Heller defendants request that this court not only affirm Judge Shenko's order in all respects, but we also ask that the Heller appellee's October 21, 2020 motion for attorney's fees be granted as to entitlement and remanded for determination of the amount. Thank you.
Thank you. Ms. Newell, you have 4 minutes.
Thank you, Judge Morris. In response to Mr. Waldman's discussion of the general release and particularly the request for sanctions based on the appellant's position on that, Mr. Waldman went into extreme detail on how much they tried to tailor this general release to cover this exact scenario. But what is left out of that general release and those efforts to narrowly tailor are these precise proceedings supplementary to execution. This is a statutory mechanism that has long been in Florida law. It is not referred to in this general release. This court, the second district in Mulholland, discussed a release of all actions which a first party may ever have had or hereinafter can have or shall have by any of its predecessors, etc. And it specifically said that that general release language is binding on claims which had matured at the time of the release was signed. This court in Mulholland versus USA at 771 Southern 2nd, 567, that's a 2000 case, reversed, and this was on summary judgment, a finding that a release barred claims because the trial court made no findings as to when the plaintiff's claim had matured. That is what was being discussed by trial counsel when it made that statement in the hearing. There were considerations as to whether and when this chose of action had matured. Certainly, this release is too general to actually encompass those future claims. This exact judgment, and in response, I will say to Mr. Cole's statement that MP had no right to be paid in this case, it is the holder of an unsatisfied judgment, and that judgment did not occur until 4 months after that general release happened. Had the parties intended to reach into the future to grab unaccrued claims, it had to do so specifically. And there is no language in this release that states future. There is no language in this release that states unaccrued. And the law of this court that was affirmed by the Florida Supreme Court in Mazzoni Farms is that this release cannot encompass future and unaccrued claims. That in and of itself warrants the reversal on this rule of law, but even more so the fact that the court did not consider whether the choices in action were unaccrued or not. And I would like to quote Mazzoni Farms, when you broadly interpret releases as Mr. Waldman would ask this court to do, so that it can encompass anything, it's a project built to doom and failure because everything is related to everything in this world. as many a curbside philosopher would say. So that's not the law of this state. It's not future. It's not unaccrued. So it doesn't cover this proceeding supplementary to execution. That MP has every right under the statute. It was never challenged that he is a valid holder of an unexecuted judgment as stated in the motion, was stated in the affidavit, and these in-pleader defendants did not take the opportunity and indeed obligation provided to them under the statute within 7 business days of challenging those findings. I would like to respond to Mr. Cole's statement regarding a waste of time in this case. It is the in-pleader defendants who created the time constraints in this case by not following the statutes. When we talk about the sophistication of the parties in this case, surely they are familiar with reading the statute and understanding what a notice of appeal is requiring it to do. This was brought up in the trial court. A motion was filed for their failure to file the affidavits, and then thereafter, they filed the affidavits within a week of that motion being filed. As a final point, as to the outrageousness of this set of facts, Judge Morris, I tend to agree more with you that it is outrageous what happened to the underlying plaintiff in this case, Ms. Williams, and the duration of her journey through the legal system. If indeed she had obtained or had retained Heller under the representation that Heller was going to take care of her and pay all of her prior counsel's liens, that is a travesty. And quite frankly, it seems to me that the in-pleader defendants are mincing words over what that promise actually was without producing any evidence of what it says. And the case law is clear. It is the in-pleader defendant's duty, burden of proof to come forward with evidence to represent why it should not be subjected to recovery. Also, this court in fundamental long-term care holdings, which is 2016.
Newell, I've given you more time than you actually were entitled to because I assumed you were bringing it to a close. So please do that now. Okay.
Thank you, Your Honor. I will. The statutory procedure set forth in 56.29 controls. That is what this court said in fundamental long-term care. Because of that, this court should reverse the trial court's order dismissing MP's in-pleader complaint with prejudice as a matter of law. It should reverse the order vacating the notices to appear and order granting motion to initiate proceedings supplementary. And it should further reverse the order granting the in-pleader defendant's motions to stay the proceedings, to cut off the time frame in order to determine this threshold question of whether the legal procedure would be appropriate or not. On remand, the trial court should be instructed.
Thank you, Ms. Newell.
To
Thank you very much. You're way over your time now. Okay.
Yes.
Thank you.